I take one day off work because my dad's visiting, and I miss something important. Go figure. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so a few days ago, we talked about the fact that we were still waiting to hear what the Supreme Court of Idaho was going to do with Bryan Kohberger's appeal. Now, for those of you who have been following along with this case, you know that Bryan Kohberger's team filed a motion to dismiss the grand jury indictment twice. Yes, they brought this in front of the court twice, and both times it was denied. And then they put it with the Supreme Court to see if anything was going to change. And I found it interesting that Judge basically stated in, a statement about the situation that he was pretty much just hoping that the Supreme Court was going to follow his lead with these denials. Well, it looks like they did. Now, it is bright and early, before 8 a.m. on Wednesday morning, and right now, this document pertaining to what happened in the Supreme Court is not available on the Idaho website attached to the Bryan Kohberger case. Instead, we're going to go over the Idaho Statesman article that has the document at the very end. So this was written yesterday around 7 p.m., and it states Bryan Kohberger's attorneys appealed grand jury indictment to Idaho Supreme Court. It ruled. The Idaho Supreme Court on Tuesday denied a pretrial appeal from attorneys representing Bryan Kohberger, the man charged with killing 4 University of Idaho students. The appeal stood to delay his murder trial further if granted. Kohberger's public defenders had argued that a grand jury sat by prosecutors for the case improperly indicted their client on 4 counts of first-degree murder and 1 count of felony burglary. They contended that Idaho law left open the idea that grand jurors must reach the higher legal standard of beyond a reasonable doubt, which isn't true, the same as at trial to convict the defendant, rather than the long-standing threshold of probable cause to indict. And again, you guys know my feelings on that situation. With that being what their argument is, they were getting nowhere, because that is literally them wanting to rewrite everything for reasons that are not true. Every case ever has been handled under the threshold of probable cause to indict, not beyond a reasonable doubt, as if it's an actual finalized trial session. And I don't understand why this is the way they decided to go with this whenever there's actual things that we're hearing, like how they have cast information in the exhibits for the PCA, but now we're hearing all this time later it's a draft with only one actual date finalized. Let's talk about that in the motion to dismiss for the grand jury, because you know that this information was presented at the grand jury. So I don't know why this is the argument they chose to go with. It seems like there's better ones. I'm just saying. In the one-page Supreme Court ruling issued Tuesday afternoon, and I'm going to pull that up here in just a second, the justices offered no legal rationale for their denial of the motion to appeal from Kohberger's attorneys. The document was signed by Melanie Gagnapane, clerk of the Idaho Supreme Court. The appellate case is now closed. State Court's spokesperson Nate Papino told the Idaho Statesman. The justices took over a month to dismiss the appeal after Kohberger's attorneys filed under seal in early February. Prosecutors opposed the appeal, also under seal, on February 20th. Now, the rest of this is just the recap of the case itself. It's literally just like those 2 paragraphs. Then it goes on to have the Goncalves family response to this. The judge overseeing the Kohberger case, Judge John Judge of Idaho's 2nd Judicial District in Latah County, twice since December, denied the defense's request to toss the grand jury indictment on several legal grounds, including the argument over the standard that needed to be met. That was my whole thing. Because just like I said, they would literally have to retry how many thousands of cases? How many thousands of cases would end up having to go back in front of the court because all of a sudden, because of this case and their delulu, I'm just going to say, they suddenly felt as if the actual precedent is different than what they've been telling us this entire time, than what they've been doing this entire time. They can't just go in there and be like, oh, this is how it's supposed to be, and this isn't actually how it went. They have no proof whatsoever that they're giving the courts, apparently, that the entire thing was without a doubt, reasonable doubt and reasonable doubt only, and not probable cause to indict. So I don't know why this is the fight that they're choosing to fight whenever they don't have any proof of it. They don't have any recordings where it's being said to the grand jury, apparently, because they have the transcripts, right? They have the transcripts. They know exactly what happened during the grand jury setting, and they're not coming out and being specific. They're not coming out and being like, this person said this to the grand jury, and that's what the problem is. If they would have somebody literally on the record stating to the grand jury that their whole entire job was to find this as serious and finalized as an actual trial hearing. No, they don't, because if they actually had that where someone was actually giving false instruction, it would be on the record and we wouldn't be fighting these 3 failed fights now for it. So again, I don't know why Ann Taylor is choosing this fight to try to fight whenever it seems like there's real evidentiary issues that she could actually be fighting here. And I know a lot of people are going to say, well, that's because she knows her person is guilty and she's just trying to waste time. Well, maybe, but both sides have been wasting a lot of time. Both sides have been doing a stupid little dirty dance with each other. It's getting really old. This just goes on to state that the Goncalveses stated that this was no surprise. No one thought that the Supreme Court was going to grant an interlocutory appeal. I just really hoped that Ann Taylor was giving something different. That's what I mentioned. That if they actually took this on, we might see some true justice happening in this case because something just doesn't feel right. We all agree something doesn't feel right. But for them to just keep arguing the same stupid argument that has no stance, no backing, no proof, no evidence, no nada, I don't get it. Like I said, and like most of you guys know, every time there's a hearing, we hear something else. Every time there's a hearing, it doesn't seem like anything has happened, but we get tidbits of information about how this investigation is really going. The state is acting like they've never tried a death penalty case or never tried a case before in their life, acting like getting thumbnails of x-rays is appropriate, and it's not their duty to be like, hey, home skillet, this isn't right. You need to give me the full-on x-rays like this is supposed to happen. Instead, they're waiting for the defense to say something to them. And the defense, I feel again, and people argue with it, that's fine. I don't care if you argue with my opinion on this. The defense isn't doing what they're supposed to be doing. There's no reason why after all this time, they still have 400 people to talk to in the innocence phase of this entire thing. Have they not been interviewing anyone? Have they not been talking to anybody whatsoever at all? Because that's what it seems like. And yes, I know that she's also mentioned about how, people just don't want to talk to us. Okay, but is that just like one person they had some like bad luck getting a hold of and she's using that as a generalized statement? Because you can't trust either side. And I know people want to just be like, oh, but she's the one who's on the defense. She's the one who's going to know all of the tips and all the tricks. Okay, but they both get paid from the same bank account. Okay, I don't trust either side. They both work for the same person. That's kind of like the whole point. I just feel as if this was a waste of time. And I know people are going to argue, and that's fine. I don't care. Have your opinion. I'm going to keep mine. I feel like this whole thing was a waste of time if this was the argument that they were going to keep harking on. You guys know there's evidence of other things that could be used here that makes a whole lot more sense when it comes to what happened in that grand jury. They have the transcripts. They know the evidence that was presented. Okay, if they know that the cast was incomplete and that was used as evidence against Bryan Kohberger in the grand jury indictment, then why couldn't they use that as just one shining example of why it should be dismissed and this should go back to normal scheduling? And we need to start back at a pretrial hearing, a preliminary hearing, and actually have both sides come out and give their evidence and get this over with. Because now there isn't going to be a holdup in the murder trial, but the state and the defense are going to continue to play games. And now I know that we went over a paper and it showed that Ann Taylor was requesting deadlines for things that went past the whole March of 2025 thing. And of course the state is objecting to it. But how much do you guys want to bet this shit is not going to happen in March of 2025? These games are just going to keep on getting played. Unless something politically changes in that area, okay, this isn't going to happen anytime soon. Now, here is a document itself, and it states, a motion for permission to appeal from interlocutory orders and motion to seal defendant's motion for permission to appeal from interlocutory orders were filed by counsel for defendant on February 8th of 2024. An objection to motion for permission to appeal from interlocutory orders and motion to seal plaintiff's objection to motion for permission to appeal from interlocutory orders. Dr. Seuss and all these dang freaking titles, were filed by counsel for plaintiff on February 20th of 2024. Therefore, after due consideration, it is ordered that defendant's motion to seal defendant's motion for permission to appeal from interlocutory orders and plaintiff's motion to seal motion for permission to appeal from interlocutory orders are granted. It is further disclosed that defendant's motion for permission to appeal from interlocutory orders is denied. They're sealing it. They've granted the motions to have this entire thing sealed while also denying the motion itself. And this actually comes like at an interesting time because we just saw the documents of the defense wanting to augment the record. And whenever we were looking up the definition of what that means, it's as if something's missing in the appeal. Well, does that mean something was missing in the appeal that has now been denied? Because if so, what does that mean? Like, what would happen if that is the case, that this was denied, but now they're claiming that, oh, but something was missing? Can they resubmit this to the Supreme Court? Can they do this all over again and now include everything that they're claiming was missing, if that's the case? See, look, like we've had more movement in the case, but now I just have more questions because of the augment the record situation versus now this denial. Okay, yeah, I've got to give this a little bit of thought because now I'm just curious. I'm going to have to go look around and see what this means, what other steps that they can take at this point. But that's if these two things are related, and I really do think that they are. But that is it, you guys. If you like the way that I present this information and give my opinion, please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. Go out and do some good today. See y'all.